billing, first thing you always have to realize is that there's no billing until you're sent a bill. Which means that what must have happened and you sent a bill. Indeed, under the Legal Profession Act, you cannot sue a client for unpaid fees unless you have delivered a bill. And you can only start the action a month after you have delivered a bill. And I'm not just saying this, Section 30 of the Act is now upheld by the Supreme Court. So there must be a bill. How do you arrive? So that's what they call the bill of fees. Now, how do you arrive at the bill? We will get to the mechanics of it, but let me tell you that literally, it is for you and your client to determine, subject to the rules that exist in the jurisdiction, what you agree on with your client. There are a few kinds, I'll share them with you, and later on you can get the details. There's one that's usually called a retainer. Now, a retainer is paid to the lawyer to see a matter through to its conclusion. It's a single advance payment, or maybe recurring, for example, month. It may be a year's retainer, a month's retainer.
It's been 2 weeks of educating you on lawyers' etiquette and conduct professionally. And you have been asking for this particular subject because you brought it up so often, the legal fees. As someone who is seeking the services of a lawyer, what should you pay and what are you supposed to disagree to pay? What is it that the lawyer cannot or is not allowed to charge? And that's why we're here this afternoon with the very best to give us platinum education on what is known as billing or legal fees. Esene Okudzeto is Deputy Managing Partner, Sam Okudzeto and Associates. Thank you so very much for making time to join us on The Law.
Thank you, Samson, for having me as well.
Great. So you're welcome to The Law. This is your legal light. It is your health law. And as we began to canvass for you the last time, we will be expecting your questions once again. There are some of them you sent, we will use them. But we will be expecting your questions one more time on legal fees. So we have been told by a number of lawyers that the law is a profession.
Exactly, yes.
And that historically, there were just 3 professions. Divinity, that is the clergy, medicine, and law. The priest made a commitment to poverty.
That's so.
And the medical professional also made a promise, a pledge to save lives. The lawyer was to read and help his client so they wouldn't take fees. That's why there is the pouch behind our gowns. So when you are done with your work, and Yaopon was saying the last time, they would drop their little coins in there.
Yes.
How come we now talk about billing and fees?
Okay.
Why? Is it a business?
Law can be a business.
Right.
It's a profession, like you said, but it's also a service that is offered. Now, when you offer a service, there's a fee that goes with that service. I mean, we do go and get so many services, like the best one is wedding. The planner, you would pay the planner. Similarly, for a lawyer, there's a service that is rendered, and so we have to be paid for that service.
Right. How does the lawyer go about the fees or the billing?
Yes.
As a potential client, what should I look forward to when I'm getting into a law firm or getting to speak to a lawyer on the phone, however I'm reaching them to engage them for my service?
All right. So basically, as lawyers, we are guided by our professional etiquette rules. And the rules make provision for the fact that your billing should be reasonable and you shouldn't undercharge or overcharge. We have what is called the GBA scale of fees, which guides lawyers in the way and manner in which the fees they would charge. So first, you look at the scale of fees and advise yourself. Okay. You have what we call an initial consultation fee. So when we meet the client initially, we have an engagement with the client where the client tells us what their problems are. Then we give an initial advice. For that, you charge a consultation fee. Okay. The scale of fees...
Just like I enter into a hospital.
Exactly.
I pay consultation fees.
Exactly. Okay. It's similar. It's the same thing, and that's the best example you can give. The scale of fees makes provision for, depending on the age of the lawyer. You have 10 years and above is $2,000. When you come to 5 years to 9 years is $1,500, and below 5 years is $1,000. Then we have the component for foreign clients as well. Have you just mentioned the minimum or the maximum? Those were the maximums I was mentioning.
Okay. Yes. So previously and recently, the fees have been updated.
Exactly.
So that a lawyer who is classified as senior lawyer like yourself,
yes,
your minimum is $2,000 and your maximum is $4,000 per hour. Is that it?
So that is the hourly rate.
The hourly rate.
For the consultation fee, the maximum is $2,000. It's a flat fee for the whole thing for the consultation.
Right.
Yes.
But when you're dealing with a population that may not be so much capable of affording the fees.
Yes.
So when I come to the law firm, do I have the right to say I want to talk to a junior lawyer rather than a senior lawyer? So I'll pay $1,500 for $1,000 instead of $2,000 for consultation?
I don't, for a client, it's not the best to say that.
Right.
So for our law firm, for example, when you come in, we do an assessment of what your claim is, and we know which particular lawyer who has an area of expertise in that area who you would meet.
Great.
Yes, in the initial engagement, you'll be advised these are the range of the fees. If the client says they have a bit of a difficulty paying, we may look at whether or not a senior lawyer for this particular matter should come in because a junior lawyer would have the experience as well.
Okay.
So we may consider that depending on the nature of the initial consultation.
So you just told us about the local fees. You are about saying foreign or is it international? Take us there.
Okay, so for the foreign fees for the consultation, for a senior lawyer 10 years and above is $500 to $1,000 maximum. Counsel, which is 5 years to 9 years, it is $375 to $750 maximum. And for a junior counsel, which is under 5 years, it is $250 to $500 maximum. So for that one, there is a range.
Okay.
Yeah.
So you've just spoken about consultation.
Yeah.
That's just the point at which the lawyer gets to assess your need.
Yes.
And tells you what you really need to do in the circumstance.
Exactly.
How about doing the thing for the clients?
Okay.
Yeah.
Okay, so with that one, our scale of fees has, you could segment the fees, okay?
Right.
So you have fees for litigation. So you have fees in the circuit court, district court, high court. Then you have fees on appeal, which is the Court of Appeal, the Supreme Court, and if there is a review. Then you have fees for specialized services, okay? And for specialized services includes power of attorney, statutory declaration, notary public fees, and given a legal opinion.
Okay.
Then you would also have fees for conveyancing, which is assigning a property or giving out a property. There's a certain amount that we are supposed to charge.
So you want to buy a land, for example, and you need the documents to be done to cover the land.
Exactly.
Because land is not just bought with a receipt.
Exactly.
Okay, so that's conveyance.
That is conveyance.
Okay.
Then you have for incorporating a company, for incorporating a partnership. We also have compensation claims. So for example, debt recovery. Or in respect of maybe government is building a road and your house is affected and you have a claim against government for compensation.
Right.
There's also fees for that one. Then you have fees for appearing before statutory bodies. The Labour Commission, STRAJ, whichever statutory body it is. We have the amount we would charge in that one. Then you have debt recovery. For debt recovery, there are two. We can do a recovery by writing a demand letter and then entering into negotiations.
You can do a recovery without going to court?
Oh, yes, we can.
Okay.
Just the fact that a lawyer has written a letter is enough to deter the person to enter into a negotiation or even to pay the fees because they do not want to deal with court.
Right.
Then you have where you have to go to court proper. There's also the fees that will be charged. And then we have what we call our hourly rates.
Right.
Based on that. We have what we also call a contingency fee. That mainly is used in debt recovery or high-end matters. And with that one, it's either a flat fee or it's a success fee, which is based on a percentage of the claim, or you have a mixture of a flat fee and an hourly rate. So it's different mixtures depending on what the client's.
Great. You're still here on the law. This is your legal light. It is your help law. And we're being helped by SNA Okudzeto, Deputy Managing Partner, Sam Okudzeto, and Associate. And I go back to where I began.
Yes.
In the law school when I was being taught.
Yes.
And Senior Sam Okudzeto enters the classroom and begins to ask everyone else, why are you here? What is your motivation for doing the law?
Yes.
Immediately we begin to speak, he puts a caveat. Don't tell me you are here for the downtrodden. Tell me the real reason you are here, because there's money in the practice.
Exactly.
So the attitude is that you go in there to give a service not particularly for financial reward. Is that correct?
It differs, okay? Yes, we do a service. And you know, each law firm would have what they call pro bono, where they do not charge for those kind of services. So we do have our pro bono. Then you do have the reward system, which is you get paid for what you do. And so despite the fact that the precedence of law was on the basis that you were doing a service to mankind, right now there is a need to pay for that service. And we even have now where people are seeing that law firms need to be organized as a business because you have staff. The staff needs to be paid.
Right.
And the only way you can pay them is if you charge clients.
And as we understand now, the Professions Act,
yes,
Isankuma says 4 times uses the word business
yes,
to describe the profession.
yes.
So it is in fact a business.
Exactly.
And therefore has to be approached as a business. I've seen some questions already. We'll begin to go to them, but let's begin step by step.
Okay.
What are the forms of billing that a law firm typically engages in with their clients?
Okay. In terms of the forms of billing, I've given the wide categories.
That's right.
So forms of billing will be your initial consultation fee, then will be your invoice for whatever legal service you have.
Right.
Then we also have what we call out-of-pocket. Technically, that's not billing, but you can't have a discussion on fees without discussing out-of-pocket, because this is a cost to the client, which are costs in respect of filing fees, transportation, use of internet, stamping of documentation, like it covers a wide variety, printing costs and so on. You agree what those expenses are and which one the client would pay and what the rates are. So for example, transportation, how are you going to figure it out? Is it rates per kilometer, per mile, or is it a flat fee? When you go outside Accra, there are certain expenses that are incurred. Is it a 4-wheel drive, for example, that is taking the lawyer, because the lawyer needs to rent a vehicle. The lawyer needs to arrive safely. He can't just take just about any car to get there. There's a cost involved. There's petrol involved. So you need to factor that all in as well. So those would be the different types per se. Yes.
Right. We have heard about retainers.
Yes.
We've heard about flat or fixed fees.
Yes.
Help us understand them.
Okay. So a retainer fee is just that you engage a client and it covers some services. Okay? So for example, the retainer may cover legal advice, just about any legal advice, drafting of routine contracts, stamping of documents, maybe trademark, representation before lower courts. Depending on what you and the clients agree, that would be the retainer fee.
Okay.
The retainer fee can be a monthly fee, or it can be an annual fee, which is payable in quarters, or it's an outright payment. A flat fee would be guided.
So the retainer
Yes.
is paid in advance
Yes.
for work that you have to do.
Exactly. So it covers the services for that period. And a retainer also can include the use of the lawyer's name, because in annual reports and so on, you would indicate the fact that this is your lawyer.
Right.
And so it's the use of the lawyer's
So
name.
it is possible that especially corporate organizations will need to retain a lawyer.
Exactly, yes.
And it is possible that they will retain a lawyer and make the agreed payment, which is, you said, either monthly, it can be quarterly, it can be yearly.
Yes.
And they make those payments and yet may not give you work to do.
There is that possibility. So what we always advise our clients is look at the nature of what kind of legal services you have or you would need. You know if you have a lot of labor claims, so you would need somebody on retainer. And the idea of a retainer means that the lawyer is available all the time.
Okay.
It's not now that you're going to engage the lawyer to tell the lawyer what it is. You send an email or you set up a meeting with the lawyer. You tell the lawyer what your problem is, and the lawyer goes and does whatever service it is. So under the retainer as well, the scale of fees says that when it comes to other services not included in the retainer, you get a discount of 20%.
So you are entitled
You
to
are
that
entitled to a discount.
20% automatic.
Yes.
Because you have
Depending on how you
engaged the
negotiate.
lawyer on a retainer basis.
Yes, exactly. And it means that the lawyer is available all the time. If you are a walk-in and you're not having a retainer, you would now call and we need to set up an appointment. But
That's
most of
right.
the time for lawyers who have clients on retainer, the clients on retainer do have a priority.
Right.
Yeah, so they are at the police station, they've been caught. I'm at the police station, I've been caught. You need to get into your car and
You must
attend
get there
to-
immediately.
Exactly.
Right.
Well, not immediately, bearing traffic rules and everything,
right.
but
All
as soon
right.
as possible, yes.
Right. So once they have the client as a retainer with the lawyer,
Yes.
as you said, then they have retained your service, or either that you have retained their money, and so they have a right to you.
Yes.
So they can give you all sorts of work to be doing
Within the scope of the retainer.
within the scope of the retainer.
Exactly.
Okay.
So one of the main ones is if you look at reviewing of a contract. I say routine contract, okay?
Right.
Routine contract can be, I would review a contract if it's more than 2 hours, then it's a different scale of fees because it's outside the retainer.
Okay.
It can be based on number of pages as well. Like if it goes over 25 pages, we're outside the retainer, then we would engage and find out what the fee would be.
Right.
Yes.
So the first form of billing you have just learned is the retainer. And it can involve a once or a single payment. It can involve payment that is recurring, and the service of the lawyer is retained for as long as the contract,
So Samson, let me
is-
add,
yeah,
there's a form of retainer which is not particularly in Ghana. In the US, they have what the concept of a retainer, which means I deposit money with you in respect of my hourly fees.
Okay.
So I have deposited it, and then the lawyer deducts based on the number of hours. But that's not envisaged
So
by our...
when you work,
Yes,
then you would have computed the hours of work
exactly.
on the hourly fee basis.
Yes.
And then you go take that money
Yes.
because it's already been put in your account.
Exactly.
You only have to account for it. Okay.
Yes.
That sounds good.
That's a good one, right?
The money
For
just
us
sitting there.
lawyers.
I just need to work and claim it.
But you justify the hours.
That's right.
There has to be a justification
Right.
where it's either what you discuss with the client, but on a monthly basis, you send the number of hours you've worked.
There's a timesheet.
That's a timesheet, exactly.
Okay.
And you indicate what you have done to
And
be able
these
to
days,
qualify
we
for
understand there are softwares.
Yes.
When you begin the work, you will click start. When you stop, then you click stop. Then it's
Exactly.
shown how many hours you have done. So your client will not be shortchanged.
Yes.
If you tell them that I have worked for 5 hours, there is proof that you have actually worked for 5 hours. So
that.
you take that money.
Yes, there's actually software which can be put on your laptop or your computer, which actually automatically starts recording for you.
Okay.
And so even with that one, you'd agree. So for example, some would even say if it's under 5 seconds or 10 seconds, I would not bill.
Okay.
So it's over that, then we start billing.
So typically, how many minutes would the lawyer work and insist that that is an hour's work?
No, so it's an hour. If you are charging an hourly rate, it's, to be honest, it has to be an hour.
You must do the hour.
You must do the hour. So if you do under the hour, you'd do the calculations. 30 minutes.
Okay.
So if it's 800 an hour, 30 minutes is 400. So that's the easiest way to calculate the fee.
Great. Thank you very much. Now, we are going to the other one, which is the flat or the fixed fee.
Exactly. Yes.
What is that one too?
So with the
but let's
yes.
be clear about this. The retainers, they are normally by companies, corporations, not individuals retaining. I hear people say, we need a family lawyer. I'm like, it's like they're looking like a family doctor kind of thing.
Yes.
Does that apply in the legal profession also?
Yes, so individuals, I mean, there are individuals who know that they have legal issues. So yes, then they would have a lawyer on a retainer. So or it's somebody who has, within a certain time period, is just inundated with all kinds of legal problems, and so would get a lawyer on retainer for whatever.
So that they pay them either monthly, quarterly, or yearly, and then anytime they need a lawyer service, the lawyer is available to provide the service for them.
But we advise that you only use the retainer when you have a lot of legal work, because that actually saves you having to negotiate each time with a lawyer. It could end up being cheaper for you if you have quite a large number of hours that the lawyer has to spend with your work.
Right.
Yes.
Before we go to the fixed fee or that, I understand there is also a kind of a retainer where a firm does what's like a secondment. So the corporate entity comes to say, I'm going to do this, and I'm going to need a lawyer in my office to help me. So give me a lawyer. How does that work?
So there are different forms. I mean, you can agree on a fixed fee, which we'll come to, or you can agree on a retainer, which is for this the person is going to be available for this number of hours or this specific period of time.
A year or two. Or
sometimes,
for the duration of the project.
Exactly. Or even sometimes we've had clients who come in and say, look, I have a particular issue. I don't have a legal person in-house, but I'll need your lawyers once or twice a week. They come and spend the full day going through whatever legal documents we have and then advise.
Okay.
Yes.
And whatever legal documents could include that people have written letters to the company and they need a lawyer to review and advise how to reply them and so on.
Or even bidding for a contract.
Okay.
And there are legal documents involved, so you want that person to be available with a team that is working on the RFP, and so they'll be available, or they should make themselves available, basically. Yes.
Great. I suppose that you're really enjoying it up to this time. This is the law. It's your legal light. It is your health law. And our guest is Esene Okudzeto, who is Deputy Managing Partner, Sam Okudzeto and Associate, helping us to understand the range or regime of legal fees or billing, so that when we are approaching a lawyer, or if we are also lawyers and perhaps we may have forgotten some of these, she's helping us to get them to a point where we will not find ourselves in trouble. So let's go to, is it a fixed fee?
The fixed fee, yes.
What's that?
So with a fixed fee, it's a set fee, which covers whatever service. And the main one we normally use, the fixed fee, is litigation.
Okay.
So you have a land matter and you are going to court. You agree a fixed fee with the lawyer saying that for this particular dispute, this is what the lawyer is entitled to. And for land matters, for example, it's 10 to 20% of the value of the land. So you would have a estimated value of how much that land is, and then the fee would be, you negotiate with the lawyer between the 10 to 20%. And mind you, that negotiation has to do with the skill sets, length of years of the lawyer, and the novelty of the case as well. Then you determine what that range would be. If the value between 10 to 20% doesn't cater for the type of litigation, then you would move to the hourly rate. Okay. So basically, you are going to negotiate with your lawyer, whether it's between 10 to 20%, then that is the fee covering the litigation. Let me add a caveat. Our scale of fees also makes provision for a refresher fee. So if it is over a year, then there's a little bit of a refresher fee, but that's not as much as this one. It may be some amount, 1,000,
so we
2,000,
agree
5,000.
on a fixed rate.
Exactly, yes.
And the fixed rate we have agreed on is based, we are using a land litigation, for example.
Yes.
It's based on the value of the property.
Yes.
Or if it's a house or something.
Yes.
Then, in the course, if the case travels beyond a year,
Yes.
the client is subject to a refresher fee.
Yes. Which has to have been negotiated. If the lawyer did not negotiate a refresher fee, then they are not entitled to charge that refresher fee. And basically, when you say it's a fixed fee, that means however long the case is in court, the lawyer cannot charge you any additional fee.
Right.
And then you agree that this fixed fee is till I get judgment. Post-judgment processes is another leg.
Right.
So you either agree with the lawyer that when I get judgment, that's where it ends, or it includes post-judgment process. So for example, post-judgment means like for debt recovery. The court has said you are entitled to a certain amount of money. They have filed an entry of judgment on the other party, and the other party is not paying the money. It means you have to go into execution.
Right.
That is an additional step that the lawyer has to take. Does your engagement with the lawyer, your terms of engagement say that the lawyer is charging for those additional processes, or it's included with the initial fee? Then you also have if there is an appeal.
All right.
That's another one where you can negotiate another fixed fee.
But you refer to the scale of fees.
Yes.
Does the scale of fees not fix flat fees for this? Like fixed rates? If it is a land matter, you have given the range it gives,
Yes.
a certain percentage on the value.
Okay.
Say I'm taking a human rights case.
Yes.
Say whatever it is. Does the scale of fees not say I shouldn't pay more than X amount?
Yes. So even this 10 to 20%, you can't go beyond the 20. Unless you are doing the hourly rates, because the 20% doesn't take into account the level of work involved, okay? Now, we have different forms of litigation. So let's go to probate. I think the easiest for that question would be probate.
But before you get to probate,
Yes.
we are not forgetting that.
Yes.
You spoke about refresher fee.
Yes.
The refresher fee, there's a caveat to it, that if the case has done a year or beyond a year,
Yes.
and the delay is not caused by the lawyer.
Exactly, yes.
So how do I say that the delay was caused by the lawyer, so I won't pay the extra? How do I come to that?
So for the delay caused by a lawyer, it could mean that the lawyer was unavailable. For example, you've done the initial process, you filed the writs, you've done the pleadings, have closed, you've taken directions, you filed your witness statement. It's now time for trial. The lawyer is not available within that year to take on that trial because you are insisting that you want a senior lawyer or something to that effect, which means you're going to have to go over the lawyer. Technically, the delay was caused by the lawyer because the lawyer was not available.
Okay.
It also means that a process was filed in court and the lawyer could not come. And so the matter had to be adjourned for that process. Or the lawyer is in two different courts and can't come to that court, or the lawyer was sick. And so there have been some delays occasioned by the lawyer. Yes.
You said the lawyer could be sick.
Yes.
The lawyer is a human being.
Yes.
So if he is sick and the case is taking over a year,
Yes.
is he not entitled to his refresher fee?
No, because the delay was occasioned by the lawyer. Mind you, when a lawyer is sick, we are still supposed to have another lawyer appear in court. We are not allowed by professional etiquette rules to leave our clients in a lurch. They have to be in court. But in this situation, the lawyer is the one who is asking for the adjournment because they are unwell and cannot come to court. So they would have some other lawyer come into court, but they would ask for an adjournment.
Okay.
Yes.
So now you know when your lawyer is not entitled to the refresher fees. But you can be flexible about it depending on how you and your lawyer discuss and
Exactly.
what services you think you are getting from your lawyer. Sometimes your lawyer is going the extra mile, doing a lot of good work for you. And so you may overlook some of these things. But this is the rule. You were going to help us with more examples of the flat fee set by the rules that the lawyer is supposed to comply with. This is the law. It is your legal light. It is your help law. And our special guest helping us with the education on billing and legal fees is Esene Okudzeto, who is Deputy Managing Partner, Sam Okudzeto and associates. Yes.
Okay. So instead of going to probate, I think an easier one is conveyancing, which is not litigation. But like you said, conveyancing is you have a property and you are giving it to another person, either through a sale or some other means. So for conveyancing, what it says is that if it's also based on the value of the property.
Okay.
If the value of the property is over 40,000 Ghana cedis, the maximum you can charge is 15%.
Okay.
So it means that you would engage in negotiations with your client. You find out if it's 10% or 15%. When you agree that fee, it is now a flat fee because you cannot adjust, you cannot change the fee, okay? When it comes to property which is valued over 40,000 and up to 200,000, it is 15% for the first 40,000 flat. There's no change.
Okay.
You can't change that one. Then the balance you would negotiate, but the maximum you can charge is 12%. So the next is when the value of the property is over 200,000, but does not exceed 400,000. For that one, for the first 400,000, the flat fee is 12% of 400,000. Then you would negotiate the balance up to a maximum of 10%.
Okay.
When it is over 400,000 and up to 1 million, the first 400,000 is 10% flat fee. You would negotiate the balance up to a maximum of 7.5%. When it's over a million, first 1 million flat, 7.5%, and then you negotiate the balance up to a maximum of 5%. So I think this explains the flat fee adequately.
Thank you very much. You had also mentioned contingency fee.
Yes.
So I suppose that's also a different way of billing.
Exactly, yes.
What is that?
So with the contingency fee, it means that the fee is contingent on the happening of certain events. And the main one the contingency fee is used is debt recovery.
Debt recovery.
Debt recovery is the easiest.
Okay.
And so for the debt recovery, you would have agreed that the contingency fee too has different facets of it.
All right.
So with the contingency fee, you can agree a fixed fee, which is I will charge, despite whichever win or lose, I would get either 20,000, 30,000 flat fee. If I win the case, which is what we call a success fee, you would get a certain percentage either of the claim or the amount that is recovered. Mostly it is the amount that judgment is giving. It's 5%, 10% is what you would negotiate.
Okay.
Or
either judgment or you have been able to recover it. You said there are two ways.
Exactly.
Either by correspondence or by litigation.
Exactly, yes. But the contingency fee is mainly based on recovery.
Right.
So you remember I had said that you can negotiate a fee up to judgment and then there are post-judgment processes.
That's right.
Most of the time the contingency fee is when you have recovered. So it includes post-judgment. Depending on the negotiation. Some people would negotiate up to judgment because once they have obtained judgment in your favor, that is a right you have which you can action. You can even decide to contract with somebody to take over that.
You can do that.
Yes.
A client is allowed that this lawyer is going to do this job for me, go to court and fight.
Yes.
If he wins the case, he's not the one who is going to help me to get the money. He's gotten the court to say, you are entitled to 1 million.
Yes.
His job is done, he's gone, I've paid him.
Yes.
I'm going to get someone else to chase the money and get it for me.
It will be bad for the client. I wouldn't advise you to do that because the lawyer, during the entire court proceeding, has an idea of what the other side will do.
Right.
You know, based on the filings, the attitude of the lawyer, you can have a sense of how difficult it is, how not difficult it is. You also may have, part of your legal research, would have found out what assets the other person has and would know what to go and attack in courts in terms of the execution to recover.
But
go to a new lawyer, they're not going to start from scratch.
But there are professionals whose job is just to help you execute a judgment.
Yes.
So you can get a judgment and get somebody else to execute it, a professional, particularly when it's about debts owed by the government or a corporation or a company.
Yes.
And it's difficult to...
The problem is, if you have to file court processes in court, what happens if you go to somebody else who is not a lawyer?
Okay.
So you are doing yourself a disservice. So you have to advise yourself, basically.
I get that.
Yes.
I get that. And I suppose that you also appreciate the point that she just made. Now, there are many people who can't afford much. I'm going back to that point.
Yes.
So such people, do you deal with them with your hourly rates? Do you deal with them with your percentages? What do you do?
So it all depends on the client's circumstances. You would look at what their dispute is. If it's you should have a pro bono policy. And so you know who qualifies for a free service, okay?
Right.
There are certain persons, like a human rights matter, and it involves a person who has no monies, and we call it an indigent person. The
Right.
rules make provision for you to provide that kind of service to them. But you have to have a policy. Now, there are some people who can pay, but at that period of time, they do not have the funds. So your billing will take into account when they are likely to be able to pay you. And you see that a lot in the contingency fee, meaning that I have a claim, I have some monies that is owed me, but I don't have money now. So when you recover that money, then you would take your fee.
But that's a risk I'm taking.
It's a risk the lawyer takes.
Yeah.
Exactly. It is a risk. So you, the lawyer, have to investigate and find out, because part of the problem is you may get judgments, but there's no money to execute. There's no money for the judgment debtor to make payment. It means the lawyer would not get paid.
So that is why some lawyers or some law firms would demand a non-refundable deposit.
Exactly.
Then, so they will do a combination of the fees.
You have your flat fee, which means that at best I'm going to recover or get this money. So for lawyers who are acting as a business, you look at how much hours are involved and say, what can I do? And this is how much I know I should spend or I can afford for this particular case, and you charge based on that. Yes.
The phone lines are open now. You can see them on the screens. You can call us. Be very snappy with your questioning, straight to the questioning on the questioning of legal fees. I need to get my internet properly done here. There are questions that have been sent here already. There's a gentleman who says that his lawyer takes money anytime they go to court. He says, I am the defendant in a case at an Accra Circuit Court.
Okay.
My lawyer collects 200 from me each time he comes to court. Is this bad?
You see, I believe there are other circumstances. So like I said, you have your fees and you have your out-of-pocket. We don't know if this 200 is what we call out-of-pocket. Is it for transportation? What is it for? Is it a lawyer who has done a payment plan whereby they have looked at how much you are supposed to charge under the scale of fees and then saying that each time you come in, pay me 200 because you cannot afford to pay. So we need more facts to be able to advise this person.
Right. So we need to know, is it a doku dune? We need to know if this is something you have already agreed with your lawyer. But what you're saying, that if it is something they have agreed, then that is it. It's fine.
Agreed and within the scope of our scale of fees, because we are bound not to overestimate or undercharge.
We'll come to that.
Yes.
Kojo, you are calling from Aflao. Good afternoon. Let's hear your question.
Good afternoon, Mr. Sampson. How are you doing?
I'm great. Thanks for asking. Let's hear you.
Okay, my question is, if a lawyer charged me, for example, a lawyer charged me 20,000 for a case, but the lawyer's behavior makes me terminate his contract with me or his service. I terminated his service. Do I have to pay the rest of whatever left?
Okay, at a time when you have not finished paying the 20,000 cedis, is that it?
That's it.
Okay, thank you very much for your questioning. You can join us with your questions. Look at the screen and you see the contact. So, Esene, in this circumstance, what's the solution? What happens?
Again, we go into what did you agree with the lawyer? Okay? Is it a flat fee for the entire case? Is it a fee which is dependent on certain milestones. So, for example, if you say it's a flat fee, 20,000, but you would charge upon execution of an engagement letter, which is mandatory, which is basically the terms upon which you have engaged the lawyer. Our scale of fees says that you can ask for 50% once you sign it. So is it 50%? Then what are the milestones? If I file he said he was a defendant.
That's right.
So you can have, when I file your statement of defense, I'm entitled to a fee.
Okay.
When I file a witness statement on your behalf, or witness statements on your behalf, I'm entitled. When I do the trial, I'm entitled. When I have to file written submissions in respect of your case, I'm entitled.
Okay.
So the fees have been broken down.
So that they would have agreed to 20,000.
Yes.
But the 20,000 will be paid upon the achievement upon certain milestones.
Exactly.
If he takes this step, you pay X amount. He takes the next step, you pay the next tranche.
Yes.
But
that's for convenience.
Yes.
So let me add up.
Right.
That is for convenience.
Right.
If the lawyer, your agreement, because we also make provision in our engagement letters, because there's sometimes cases can be settled, where we say, even if it is settled, I'm entitled to my full fee. So now we go back to his issue. If it was decided that I'm entitled to 20,000 for the case, you decide at the end of the day that I am withdrawing, you have to pay the entire amount. It all depends on what you have negotiated. Because the lawyer can say, I am negotiating a payment terms based on milestones for convenience.
Right.
But I'm entitled to my full fee, whichever part of the matter is, wherever it's truncated.
In this case, he's the client who is making the decision that he doesn't want to continue with the lawyer.
Exactly.
But in a typical case,
yes,
where the lawyer is not interested anymore or has demonstrated such conduct that it's so clear that I can't continue with the lawyer anymore.
Yes.
And we didn't state in the agreement that the money I'm paying is subject to anything.
Yes.
I should be entitled to something back.
Under our rules, you are entitled. But the issue is how you're going to calculate it. Because it becomes a he said, she said. You didn't make provision for it in your contract.
I think we should get back to that again. Rosemond, we are calling from Teshi. Rosemond, what's your question? Hello, Rosemond.
Hello, can you hear me?
Yes, go ahead with your question.
Please, my question is that I have engaged a lawyer who has charged me, but anytime, apart from the legal fee, anytime we go to court, I have to pay an amount of 500 cedis, which is different from the legal fee.
Did the lawyer explain to you why?
No, from the explanation, they said that is the legal charges, that is what they do. Apart from the normal legal charges, which I'm being asked to pay. So this is for transport. They are CNC.
So this was agreed. So this was agreed from the beginning.
Yes, please.
Okay. Thank you, Rosemond. What do you have to say?
She mentioned it. She said it was for transport. We don't know the location. Okay. Transportation, there has to be a basis for you to agree transportation. And she is saying that they have agreed transportation 500. So it's a bit difficult because you don't know where the lawyer is coming to go to court, where the court is.
What car they are using.
Exactly, because depending whether it's a 1.5 liter or a gas guzzler,
that's right.
fuel would be expensive.
But I think that what I sense from our viewers is, should the lawyer charge legal fees and then charge transportation again?
Yes, because it's what we call out-of-pocket expense. There are expenses for the lawyer to provide you those services. You and the lawyer have to agree if those costs would be the lawyer's or they'll be yours. For example, printing. It costs. Printing can be very significant. If you have to print 100 pages, for witness statement plus additional documents, whether it's black and white or color, it's a cost. That technically should not be the lawyer's cost. It should be the client's cost.
What is the legal fees then? What is the legal fees I'm paying?
For the service,
what is it?
It's for the service. So, for example...
And the service includes the printing and the going to the court
No, it
transport.
does not.
It does not?
Let me take you to an example, a baker. You order a cake. The baker says, I'm charging you 800 for your 10-inch cake. Now, I need to deliver that cake to you. You put it in an Uber or the person puts it in a car. That's a fee. That's an additional fee. And we all pay it. We order food online on Glovo, Bolt. We pay for the food and we pay for the transportation.
Okay.
And it's similar to that.
Before I lose Kofi. Kofi, you're calling us from Babiani. Let's hear you, Kofi.
Yes. In case I engage a lawyer.
Yes.
And paid all the fees that we agreed upon.
Yes.
And the lawyer dies. Now what do I do?
Okay. That's all your question. Thank you very much.
Okay.
What happens?
So now it depends on whether your lawyer worked in a law firm. If your lawyer worked in a law firm, basically the firm has to continue to provide you the service. Whether the lawyer dies, whether the lawyer resigns, whether the lawyer, whatever happens, the law firm is supposed to continue with that service. If you go to a one-man shop, unfortunately, when the lawyer dies, your contract ends. It means you have to engage another lawyer to represent you, and it means you have further fees to pay.
Right.
Yes.
But there are law firms where the lawyers appear to just be living in some rents in the law firm. And so each lawyer there are many lawyers, but each lawyer is dealing with their case.
Yes.
How will some other lawyer in that firm be bound to take that case because a lawyer is dead?
We have a problem. In that the engagement letter would have set out who is acting, because those are law firms where it's a law firm per se, but there are a number of lawyers who do their sole businesses. And with that one, your engagement lawyer would basically say it is this lawyer who is acting for you. In such an instance, it cannot go to another law firm.
Okay. Yes. It cannot go to another lawyer in that firm.
Another lawyer in the firm, yes.
All right. Alhaji Omar, you're calling us from Koforidia. Let's hear your question.
Something good afternoon.
Good afternoon, sir.
May I know from your discussion as to the percentage a lawyer is entitled to whenever he's doing a land case for you, like on agency agreement with a lawyer to help you sell a land? How much percentage, what is the percentage a lawyer is entitled to from the
all right.
amount? Okay.
Thank you. Your question is clear. Alhaji Omar in Koforidia.
Okay. So now there are two facets to it. The person who is selling the land, is it you? Okay, it's clear. He is selling his land.
Yes, he wants a lawyer to do that for him.
Okay, so that one is easy because if you look at it, you are either drafting a sale and purchase agreement and then either a deed of assignment or a lease, depending on who the owner is.
That's right.
We have what is here, which is based on the value of the land. He didn't tell us the value of the land. I had gone through it initially, the different facets. I don't know if you want me to go through.
You could for his
Okay, for his sake.
Yeah.
So basically, if it's a value up to 40,000, it is, you negotiate up to 15% of the value of the land. If it is 40,000 up to 200,000, for the first 40,000 is 15% of 40,000 flat fee, and then the balance will be up to 12% maximum. If it is 200 and 400,000, it is 12% for the first 400,000, and the balance is 10% maximum. If it's 400,000 to 1 million, for the first 400,000, 10%, and then the balance is 7.5% maximum.
Is this the only mode of billing the lawyer can use for that relationship with Alhaji Omar?
For here, that's what it says.
Okay.
We are bound by this. If you
the lawyer cannot say this one, I want to do it by hourly basis. So you pay me.
No.
Okay. Let's go to Bafo. Bafo, you are calling us from Siani.
Yes.
Go ahead with your question.
Yes. Mine is sort of a reaction. I don't really get it, guys. I think your services are expensive. It's ordinary, because talking about 1,000 Ghana as an hourly rate, I mean, for some of us cannot access legal services. How much is it? Look at all those things. I'm surprised this person that is so low. such an expensive thing. You are telling us. Please, I think I'm surprised. This is thousands even for a lawyer for an hourly rate.
And thousand is not a senior lawyer. A senior lawyer, the hourly fee is 2,000 minimum, and the maximum is 4,000.
Exactly.
So the lawyer is entitled to charge between 2,000 and 4,000, not less than 2,000 and not more than 4,000 per hour.
Yes, and this is what I'm saying. It is very, very expensive.
Okay.
Please, it is for an hourly rate.
Right. Okay. Thank you for your reaction rather than a question. Right. So, what do you say to people like Bafo?
I understand where Bafo may be coming to an extent, but you also need to look at the flip. The lawyer has gone to school for quite a significant number of years. There's some expertise that has been obtained through that, and there's expertise that have been obtained on the job as well.
Right.
It's a service. I mean, if you come to a law firm and a lawyer is available to provide you that service, it's because he is charging. If he's not earning an income, how would he be available to provide you that service? So it's a blend. It's a blend. And I understand where he is coming from, but you also have to look at the fact you have to compensate it. If you go to the hospital, you're not going to tell the doctor that his fees are too high, so I'm not going to take use your service.
Right.
Yes.
The legal profession, professional etiquette, conduct and etiquette rules.
Yes.
2020, Rule 16.1
Yes.
says a lawyer shall not make an agreement for, charge or collect an unreasonable fee
Yes.
or an unreasonable amount for expenses.
Yes.
What does that mean?
So it has to do with transportation, okay, printing. And these are what we call out of pocket, which is expensive. So for example, how much is a lawyer supposed to charge printing one page? You have to agree on the rates. The easiest is what would printing services, where you go and you print documents and so on, you photocopy documents. You can use those charges as an example of what it is. And that would help you know whether it's overcharging or undercharging. If a lawyer is coming from somewhere Accra and going to court, are they charging 1,000 cedis for transportation? Depending on the car, depending on whichever, you now determine whether it's an overcharge for expenses. It says 1,500. So the location will also determine whether it is reasonable, but it's each circumstance, and that would help you make that determination.
We understand that if the lawyer does not have a sort of an agreement, a contract with you,
Yes.
that is difficult, and that if the client does not pay them, they cannot even recover their fees from the client unless there had been an agreement.
Yes.
And even when there is the agreement and there's a default and they want to sue their client, they need a month.
Yes.
After the agreement.
Exactly, yes. So basically, under our professional etiquette rules, you have to have what we call an engagement letter.
Okay.
Which is basically your contract between the person who is the client and the lawyer. The contract will state the basis for the fee, the basis for the out of pocket, the timelines for payment, and who is paying. Because there are times where it is not the client that is paying, it is another party who has to pay for the services.
Okay.
And our professional etiquette rules say you need to have that contract either before you engage the services or within a reasonable time after engaging the services.
All right.
So if you do not have that, when you go to court, how is the lawyer supposed to show that this is the fee that is owed me, or this is what is owed me for out-of-pocket expenses?
At what point can the client have a case against the lawyer in respect of their fees? So that we know, for example, that when the lawyer signs a retainer agreement,
Yes.
it means they cannot take a case against
Yes.
that client.
Yes. Well, we have what we call conflict of interest, okay? So now, does your retainer mean you do not represent them in any matter? Okay? Now, if you've represented a client for 5 years, 5 years ago, you haven't represented a client again, and it's in respect of an litigation matter. Now, there's a different matter. Are we conflicted? So you have to do what we call a conflict check to see if you are conflicted in representing the person.
Okay.
We also have provision for a waiver of a conflict in certain instances, because you may have done some litigation for the client, but the client is now selling their land to a third party. That third party has engaged the lawyer who represented you in the litigation, and you have gone for a different lawyer. Can you represent that person in respect of the conveyance? So long as it did not bother on the litigation case, that land did not form the litigation case, you should be able to.
Thank you so very much. Esne Okudzeto is Deputy Managing Partner, Sam Okudzeto and Associate, and she's been helping us on the law, understanding billing or legal fees. And for Alaji, Omar, and the rest, you can just Google scale of fees. GBA scale of fees 2022, and you see the whole document to use it to inform how you engage with your lawyer. Thank you so very much for making time to join us once again.
It's a pleasure, Samson.
Right, so we are so grateful for the education she's giving us today. This has been The Law. It's your legal lights. It is your help law. We come your way again next week. But of course, join us tomorrow at 11 a.m. to enjoy the show one more time.